Hello and welcome to the 37th episode of Business Litigation TV. I'm your host, Jesse David Eisenberg, and this is the internet's most passionate show about business litigation. I personally am a New York business litigation attorney, and I always mention this at the end, but if you have any questions, you can always email me at jesse@jdelaw.nyc. Now today I want to talk about the most well-known circumstance of when you can start a lawsuit before something actually happens. So there's this principle called ripeness in law. And what that is that when you want to do a lawsuit, something needs to have happened. Okay? And so, I mentioned this in a previous video, but for example, if you want to sue on assault, you have to have been assaulted. Okay? That's it in a nutshell. So, and mostly that doctrine also states when you have a contract and you want to sue on that contract, the contract needs to be breached. However, the circumstance I'm talking about, the one circumstance where you can sue before something actually happened, is called anticipatory repudiation. Okay? So, you need to have a contract. That's number one. Number two, you need to know that the other side is not going to follow through on the contract. That is anticipatory repudiation, and it happens in two circumstances. The first circumstance is they basically tell you in overt words, I am not going to perform, on X date. Okay? So let's use a house. You're selling your house, they're going to buy the house. Actually, to make this even clearer, we're going to flip it. You're buying the house. And they don't want to sell it to you. Okay? They say, we're not going to close. You have a contract, and you have a closing date, but they're not going to close. That is anticipatory repudiation. Okay? The second circumstance is when they do something that makes it impossible for them to perform. So again, you're in contract to buy a house. They sell it to someone else before your closing date. They obviously can't sell you a house they already sold, anticipatory repudiation. So, I also want to make this very clear that in those circumstances you can sue on the contract. If the other, there's a lot of nuances here. If the other side, that had the house sold to them, didn't know, you're not going to get the house. You might get some damages, like the money you put down in the contract, obviously, and things like that. Also, let's back it up and say you manufacture baseball bats. Let's go with that. And someone put in an order for 10,000 bats, and you have to deliver it by the end of February. They call you on January 1st and say, we can't go through with the order. We don't have the money, whatever that, we don't want to do it. Even though they signed a contract for it. In that case, is it worth suing over it? You still have the bats, you can sell it to someone else, That's then becomes kind of a business decision. There's also circumstances where it's even more, let's say it's one bat. You're not going to sue over one bat. You're not really damaged. Someone else is going to buy that one bat. But it's for larger numbers. That's the point of anticipatory repudiation. I was part of a lawsuit where, this was far down the line. We're talking a lawsuit that started when I was in high school. It was crazy. But what happened in that case is that, these people started a lawsuit before a case, before a large property was sold. We're talking, I think, a $10 million property or a $40 million property. I think it was a $40 million property. Anyways, what happens is then, there's this big debate that lasts 10 plus years on whether that is anticipatory repudiation when they start a lawsuit on it. Turns out it wasn't, but we're talking at least $1 million in legal fees were paid out. Unfortunately, none of that really to me, because I entered the case at a different period for a different reason. But my point still stands. It's the big deals that you want to take to court over anticipatory repudiation. And the beauty of anticipatory repudiation, is that you don't have to wait for them not to go through with the contract. Okay, under normal law, let's go back to the 10,000 bat thing. You know, you're a bat manufacturer, it's your first big order, you bought $10,000-$15,000 of equipment just to create this many bats, you know, and they tell you 2 months before you're ready to deliver the bats, we don't have the money, we're not going through with it. Well, you don't have to wait those 2 months for them to prove that they're not going to go through with it if they tell you they're not going to go through with it. And then you start a lawsuit before that. You don't have to wait the time. And sometimes it's even longer. Let's say you're supposed to, you know, for whatever reason, it was 6 months out, but they still tell you they're not going to do it. And you put out a lot of effort. You know, you have a lawsuit. Couple things to point out though. If someone tells you they're going to have difficulty performing under the contract and you don't think that they're going to have the money at the end of the day, that's not enough, okay? It has to be only those two circumstances, which is they tell you they're not going to perform according to the contract, or they do something that makes it absolutely impossible. So that is anticipatory repudiation. If you have any questions, you can call me, or I prefer you email me, Jesse@jdelaw.nyc. All right, guys. As always, thanks for watching.